So good afternoon, everybody, and welcome to a very special afternoon at the Munk School of Global Affairs and Public Policy. This is the Peterson Lecture, and I am looking straight at our former premier, in whose honor this lecture is being given. So it's absolutely wonderful to have David Peterson with us this afternoon. David is a real friend to the Munk School from its earliest days, and it's wonderful that David's gift enabled us to have the kind of very special event that we're going to have this afternoon. So thank you, David. Again. David is surprised to see me back here, but nobody's more surprised than I am. So we are extraordinarily lucky to have Justice Rosalie Abella with us this afternoon. You know, there's a very long biography here, but the biography doesn't begin to capture this extraordinary jurist, this extraordinary woman, this extraordinary wife, and extraordinary mother that I've had the privilege of knowing all these years. Rosalie Abella is currently the Samuel and Judith Pizar Visiting Professor of Law at Harvard, and boy, is Harvard lucky to get you, is all I can say. I think you all know that Justice Abella was appointed to the Supreme Court of Canada in 2004. And I should add, because I think Justice Abella would want me to say this, the first Jewish woman appointed to the Supreme Court of Canada. The honors go on and on. What struck me as I was rereading the list, of course, is how long the list is. But then something jumped out at me. Rosalie Abella graduated from the Royal Conservatory of Music in classical piano. So this is truly a polymath. She was appointed to the Ontario Family Court at the ripe old age of 29 when she was pregnant. So this was the youngest woman pregnant judge in Canada, is all I can say. She's known for many, many, many things in her career, but I think most of you would know that she was chair of the Ontario Study on Access to Legal Services by the Disabled in 1983, and changed the field, frankly. Just changed the field. So if you know anybody who has any kind of disability, and most of us have one such person in our lives, you can thank Justice Abella for the difference she has made in the opportunities that are available in Canada more broadly. She was also chair of the Federal Royal Commission, the only commissioner on equality in employment. And Mel, I hope you ask Justice Abella about the difference between equity and equality, because that is one of the things that we talk about. But again, Justice Abella set the standard, drew the lines, and set the agenda for all the work that is still going on. So it is absolutely wonderful to have you here with us. It's wonderful that David made this possible, and it's a personal pleasure for me to welcome Justice Abella to the Munk School. Now, in case you were confused, any of you in the room, that is not Mel Cappe on my right. He's 2 over. Mel, I've had the privilege of knowing just slightly less than Justice Abella. But I first met Mel Cappe when he was clerk of the Privy Council. And I was in the room. There's a long list here, too. It's really unbelievable what Mel has done. He is currently clerk of the Privy Council, only one of all the deputies at any given time is clerk. This is the most senior position that we have in our public service. He's a board member of the Canadian Climate Institute. He's a chair of the board of the Health Research Foundation. And I could go on and on, but Mel, probably the story that sticks with me longest was a meeting in which I happened to be in the room. I don't know why I was there, but you were meeting with senior levels of the civil service, and you told them they had to get better, that good enough would not be good enough for Canada, that there had to be an ambition for excellence. I would imagine that message still applies in this country, frankly. You know, finally, before I turn this over to Mel, this lecture is actually, this conversation is actually taking place at a very interesting time. I read with utter astonishment, there's no other words to describe it, about the judicial reform that was just approved, passed by the Senate in Mexico. 7,000 judges, including the Supreme Court judges of the Court of Mexico, of the Supreme Court of Mexico, will now be elected. And the only qualifications you need to be a judge and to be elected in Mexico is a law degree and a few years of experience. I hope that we will get a chance to talk about this. Mexico is an active partner of Canada. There is a rule of law shared interest in the North American continent, and I find it absolutely stunning what is happening to the judiciary and judicial leadership, not only in our own country, but in close neighbors and around the world. So this could not be a more relevant conversation. Mel, over to you.
Thanks, Janice. Maybe we should just pick up on Janice's invitation. I had the benefit of having Justice Abella with a group of 20 students earlier in the day, and we had a good conversation. And indeed, we addressed, and I'm going to ask you to address now, the question of the attack on the judiciary that's taking place, not just in Mexico, although in Mexico, but also in India, Pakistan. We've seen it in Israel. We've seen it in many other countries where a well-established judiciary that has played a role in protecting rights is under attack. Do you want to describe whether that's a fear for us in Canada or should be?
That's really depressing. What a way to start.
It's going to get better.
Yeah. I don't think any intelligent Canadian is smug. I consider us probably in every single way the luckiest country in the world at the moment. I can list, as can everybody in this room, I'm sure, concerns that each of us has about the way things are operating one way or another. But we have an independent judiciary, and we have an independent press, and we have a good public service, and we have all of the ingredients of what are the necessary components of democracy. But because we've seen so many democracies unraveling all around the world, I think it's not wise to assume that this is the way it's going to be from now on. What I see going on, and I just saw it. I think you're so right, Janice, to point out Mexico. The only other country in the world that elected their judges was America. Not all of their judges, but the concept of judges looking for public approval is so antithetical to what the role of an independent court is that it's shocking to me that it's gone on in the United States as long as it has. But it's always been there. It's never going to change. And what people used to say to me was, but you understand, this is giving the people a voice. This is democracy, and that's what I read in the New York Times today when I was reading about Mexico. People saying, good, this gives people a voice. And part of what I think is happening all over the world, starting with what's going on in the United States, is a lack of understanding what democracy means. More and more, democracy is being characterized as the expression of the will of the majority. And so the idea of electing judges is part of, we want the public's views represented in the judiciary. The whole point of a democracy is that you have legislatures who are responsive to majorities. You don't get reelected unless what you do is popular with the people who elected you in the first place. That's your job. You are responsive, and at your peril, not responsive. But in the system of checks and balances, what you need for a democracy to work are an independent bench and bar, an independent media, and the role of the courts is to be the guardian of the Constitution and to say, notwithstanding what the majority wants, notwithstanding what may be popular, we don't have to worry about getting reelected. We keep our jobs until we're 75, or some countries have 12-year term limits, other countries 70, but there is a term limit. And the idea that you abuse that term in order to become popular means you are abandoning your responsibility to minorities, because minorities have no place else to go except the courts. They may get the benefit of a good response from government, but that's not necessarily government's main job. They want to represent the views of the public. Courts don't represent the views of anybody. They're there precisely because we need an institution to provide the guardrails on what the government is doing. Is what the government doing passing constitutional scrutiny, even if it's unpopular? So to see elected judges surprises me not at all, only because it's along with the populism surge that we see everywhere in the world. But on the other hand, it surprises me because no country has introduced it. So the United States has always had it. No country that I'm aware of has introduced an elected judiciary in midstream. And if it came to the Canadian Supreme Court, we'd find it unconstitutional. But it's not going to. And what is think about it. What exactly is the response? What does the population of Mexico, who understands how dangerous this is for democracy, to have a collapse where all the views that get expressed are the majority views, where do they go for relief? Nowhere. And so the collapse of courts as an independent check on the majority views, the media will be next, because what will happen is people who are in authority enough that they want to get rid of the independent judiciary telling them what they can't do will go after the media next. And if you have elected judges, you can't guarantee that they will protect the media, because it's all of a piece, which means you end up with an autocracy. So it starts, to see it starting as one of our NAFTA partners is really scary. And let me pause to say one thing. You will hear the phrase rule of law a lot. I really don't like the phrase rule of law. Raise your hand if you know what it means. Exactly. So this is supposed to be the great emblematic mantra. Oh, I've upset somebody already. of what we're supposed to do in the West, representing our liberal democratic values. The truth is, nobody knows what rule of law means. We had rule of law in the Third Reich. We had the rule of law in South Africa. We had rule of law in the southern United States with segregation. Why are we worshiping this moniker? I don't get it. So I say we need a just rule of law, or we need a rule of justice, so that people know what you're talking about, because members of the public are going to say, wait a minute, we have laws. There is a rule of law. So lawyers who like the esoterica of these kinds of things and have written books about what rule of law means, to me, if you've got an aspirational goal to have something like the rule of law, it's got to be something people understand and want to give obedience to.
So,
Otherwise, I have no views on this.
yeah, I can see that. We've started off deep and heavy. Let's go light, okay? You were first appointed, as Janice noted, when you were 29 years old. Who appointed you to the bench?
Roy McMurtry.
Roy McMurtry. And what were your deep connections to the Conservative Party at the time?
I was the only woman practicing law in Toronto the year after International Women's Year when people said, women's groups said, we need a woman on the bench, and I was the only one anyone knew. And so that was the merit system in those days. I had never met Roy McMurtry. I'll tell you a story about my relationship with the Conservative Party. And sitting in the front row is one of my favorite politicians ever, David Peterson. So, David, in 1975, I came back from a court appearance at Old City Hall, and there was, remember pink slips? There was a message from my assistant saying, P.C. DeGeer called you and left a phone number. And I called back and asked for Constable DeGeer. And the person on the other end said, this is Progressive Conservative headquarters. I had no idea. I was so politically unconnected. And they called because they wanted to know if I would come in because they were looking for someone for the Ontario Human Rights Commission. My career is a series of saying yes to everything. And they didn't have a whole lot of choices in those days, so they knew if they called me, I wouldn't turn them down. So I had zero political connection. I had 2 kids. I didn't have time to get involved.
I mean, on the family court, you described this for some of the students earlier, your job was to deal with parents and children. You were looking after the rights of the children, but you were breaking up families. How do you deal with the personal horrors of what you see? How do you personally deal with the tragedies that are exposed to you in court?
In 1976, when Roy McMurtry asked me if I wanted to be a judge, and I didn't even know any judges at the time, I was pregnant with my second son and had a 3-year-old. I think most of us see the world through our own experiences. And my own experiences, notwithstanding a Holocaust background, was a very happy home. Mother and father who were loving, didn't have a lot of money, but we were fine. I sound like Kamala Harris. We were middle class. But I really, except for books, didn't understand what life was like for most people. So I got to the family court where every single day for 7 years, I was deciding whether to take other people's children away. And there I was, mother of 2 babies of my own. I had no trouble understanding how difficult this was for the parents. But it also was the place I learned how to be a judge. My friends in the legal profession were very compelling in their arguments about why I shouldn't accept this position. Because they said, you're a good lawyer, you're just starting out, you could one day be on the federal bench, why would you take the provincial court? It's the lowest court in the country. And I said, because they asked me. And I'm not in a position, I'm an immigrant and I'm a refugee, I'm in no position to bargain, and it sounds like a great thing to do. As it turned out, learning to listen, learning to see the world not from my privileged background of 2 healthy kids and a husband who was a great parent and a great spouse, but see what the world looked like from the perspective of the people in front of me. I didn't know that that would help me become a judge in other courts, but it helped me understand people. And it taught me how to be open-minded, like you don't come at issues from your perspective down. And it also taught me judicial humility. That you have to understand that the world is very different for different people, and when you're judging them, be respectful of how difficult and how different their lives are.
So how do you manage to maintain that judicial humility We put you on a very exalted pedestal on a bench with ermine robes. We address you honorably as you are deserved to be addressed. But there are a lot of entitlements to being on the bench, and especially on the Supreme Court of Canada. How do you maintain 2 feet on the ground?
I don't. The notion, I've met a lot of judges in my time. I don't think I've ever experienced in this country the phenomenon of judges who think they're above it all. That's a funny metaphor because they are kind of above. Canadians are very nice people, and they become very nice judges. So I never had any trouble keeping my head, because my colleagues did, but also when you've got a husband and 2 kids, there's no way you're going to take yourself very seriously. But what I think is at the core of your question is, since these are very emotional issues that you're dealing with as a judge, how do you learn to step back and develop a sense of transcendence so that you can look at the issues dispassionately? And I think the answer has to be that you have to start by acknowledging that you have views. Mm-hmm. You have to start by admitting that this is hard, that this is painful, that you feel one way or another. It's training. I had to learn how to do it because otherwise I just go in and decide based on a hunch. You can't do that. So I learned in that court, in that lowest court in the country, what judging meant, and it stayed with me all the way through.
So Janice mentioned in her introduction of you that you were a refugee. You were born in a displaced persons camp after the Second World War. How did that affect your perspective on justice? And your father was a trained lawyer as well. So how did it affect your perspective on what it means to give justice?
I will be interested in what other people's views are. I don't think I realized how my background affected me until I had kids of my own. Not until I became a judge, until I had kids of my own. Because we just grow up in the homes we grow up in, and you become the people that your homes produce. And I never said to myself, wow, my parents survived the Holocaust. How does that make me feel about the world? I didn't understand a thing about the world, but my world at home was a happy one. So that's who they were, and that's how they made me feel about the world. Safe. Canada was great. I grew up with a very strong sense that I had to give back, because we were very lucky to be able to be here. But I didn't feel that it affected me at all, except that I was really lucky to be in Canada. When I did the Equality and Employment Commission and traveled across the country and met with Indigenous communities, persons with disabilities, visible minorities, women's groups, and business and labor, and listened to how the world looked to them, that was when I started to think, I have some experience with what it feels like to be vulnerable. It was repressed, maybe. It just never came out before. That year that I spent traveling around the country and thinking about all of this was the year that I started to accept that who I was shaped by those experiences. And it made me more sensitive to what they were going through, I think, than somebody who had no relationship with that kind of disadvantage.
So in the Commission on Employment, on Equitable Employment, you created the term employment equity, which has now morphed into DEI, and it was a response to affirmative action. Do you want to just talk about a couple of things? One is, why is it that DEI has been, diversity, equity, and inclusion, has taken on a negative connotation? And in the US, the U.S. Supreme Court has just struck down the use of affirmative action at Harvard, where you teach. Do you want to just talk a bit about where this whole question of employment equity is going?
Okay, let me tell you how it started. I learned very early as a judge to make stuff up, and the Royal Commission was probably the first important place I learned to make stuff up. The Royal Commission was called Equality in Employment. It was 1984. Canada had a constitutionally protected Bill of Rights for the first time in 1982. The court had not yet decided what equality means under Section 15. And so I thought my first job is to figure out what equality means. I can't develop a whole mechanism for how to deal with equality in employment until I at least have some understanding what I think equality means. So I read every single 14th Amendment equality case in the United States. I never went to the States, but I read everything. I read all the philosophers from Aristotle on who talked about equality. I spoke to the groups to hear what they thought. Every one of them hated the term affirmative action, and the purpose of the Royal Commission was, should Canada have affirmative action? Because the women's groups wanted it. And so spending 1 hour of every 2 listening to people debate about what they thought was affirmative action, I thought, this doesn't make any sense. I don't like affirmative action the way it works in the States. It's quotas. The quotas always end up being the ceiling, and they're meant to be the floor. So I thought, why not come up with something uniquely Canadian? So I thought, no quotas, rate of change over time, and not the theory of, not the word affirmative action, which nobody gets. What are we talking about here? We're talking about fairness in employment. Fairness means equity. And so I defined equality as employment equity, fairness in employment. I also, having read everything and disagreed with all the jurisprudence in the United States, thought their notion of equality as meaning sameness, which is why they have so much trouble with affirmative action, because affirmative action treats people differently if they're members of a particular group. I thought that theory is never going to help people who are disadvantaged, because you can't treat somebody who is able-bodied like somebody who needs a wheelchair. One of them needs a ramp. And if you're going to treat them equally, then you diminish their capacity to become equal. So I thought equality really means accommodating and acknowledging differences so people can be treated as equals by having those differences accommodated. And that's really the heart of multiculturalism. I think that's why Canada is so successful in the way it does multiculturalism, because it says to people, look, there's a core set of national values we all have. You can't infringe on that. But otherwise, welcome to Canada. You can be different. You can be a Jewish Canadian, an Italian Canadian, a Muslim Canadian. You can hyphenate and still be a Canadian. The Americans, that's integration. Come into the mainstream based on your differences, based on who you are. The Americans have the myth of the melting pot, assimilation. Everyone is the same. If you are not white, you do not melt. If you are a woman, you do not want the same treatment as men necessarily. So that became, as I understood what people were actually experiencing, I realized that equality in the American system is like Anatole France's aphorism, the rich and the poor have the same right to sleep under bridges, steal bread, and beg in the streets, right? It's not the same. The surprise was that when the Supreme Court of Canada decided its first equality case, they adopted my definition of equality and discrimination, and it is now the way Canada describes equality. So equality means equity. They are, for me, fairness. Equality is fairness, treating people like as based on their differences, because that's the only way to come into the mainstream. DEI. Oh, this is going to get me into trouble.
I hope so.
You don't think I've been in enough trouble in my career?
You're doing fine.
Oh, you can come and sit here if you want. Somewhere along the line, so employment equity was the strategy of changing the rate of change of participation of these 4 groups in employment situations and throughout the layers of an organization. That was the other thing about affirmative action. Hire more blacks, hire more women, but they stayed at the bottom of the organizational charts. So rate of change over time rather than quotas, and being monitored for the rate of change over time. And not percentage, because if you've got 1 woman in a position and you hire a second one, it's 100% improvement, but it's not really the rate of change. I would say it was pretty successful for women on the whole, although it missed out on the strategy that was in the report. Was it isn't just numbers in the workplace, it's also those ancillary requirements like that make work possible, like childcare, like pay equity. If you're a disabled person, like the kinds of supports that you need. If you are a non-white person, getting rid of the racism making sure that takes place in a workplace. And if you are an Indigenous person, starting from scratch, understanding how relentlessly difficult it has been for those communities. And then I started hearing about DEI, and to be honest, had no idea what that meant. And maybe somebody here can tell me. I said, so what, employment equity is a law, by the way. It's required in Canada, it's required in Ontario. What does it mean? Is it over and above employment equity? How is it different? And what started to happen was people got confused about what the compliance requirements were for DEI, never mind compared to employment equity, period. What do you have to do to satisfy DEI? And it got to be 1 of these, 2 of these, 3 of those, which was exactly what we didn't want. And then the language. Then it became the language compliance. And that's when it started to get really tricky, because there were always things you shouldn't say in a workplace. But this became things you weren't allowed to feel or say in a workplace. And there became good guys and bad guys in a workplace. And it became, one of us is really bad because we represent a privileged or colonial settler. We used jargon instead of getting at the problem, and that was making a lot of us uncomfortable because it wasn't about the issues, it was about the rhetoric, and that got the wrong people upset about DEI. And they used the courts in the United States to get rid of it instead of adjusting DEI so that the good parts of it are retained. It was an excuse. It kind of triggered the right into hating this stuff. It was an excuse to get rid of something that was really important. So now there's no affirmative action in the United States. Blacks will not be able to get into universities the way they should have been able to. And to those who said it was reverse discrimination, affirmative action, it was a remedy for reversing discrimination. So I'm really struggling now with where we are in what the mechanisms are to improve the inclusion of people in a workplace who didn't formerly have a place in the workplace, because I think we're so busy being caught up with, is it woke? Isn't it woke? I don't even know what that means. So, but are we having substantive conversations about what is actually going on in a workplace? I don't think so. So we've been sidetracked.
So this is the David Peterson leadership discussion. Let's talk about leadership. You talked a little bit about the role of the court protecting rights and leading Parliament, and Parliament sometimes bringing change. Talk about what leadership means in terms of the law, and what's the role of the Chief Justice on any court in showing leadership?
Well, leadership, you got a premier, that's leadership. You were clerk of the Privy Council, that's leadership. Janice is head of the Munk School, that's leadership. Leadership is showing the way, having the vision and the selflessness to do what's in the public interest. This is a phrase I hear very little in the United States in the 2 years that I've been there. It's something we grew up with in Canada. What's in the public interest? They don't do it because it's an atomized politic in the United States. They, after all, came over from King George III, so their political origins were about getting away from government. They are libertarian. Government, mind your own business. We don't want you telling us what to do. We have a very different approach. They also hate groups because it's all about just the individual. So they're civil libertarian. They're good about everybody being treated the same vis-a-vis your right to vote, your right to a fair trial. They're really lousy on human rights, which is about your right as a member of a group. And we're far better at that. But so what do I see as leadership in any area? I see someone who is able to leave his or their ego at home and then do what's in the public interest of whatever institution they are running. I mean, it's that simple. Are they wise enough to know the difference between knowing a lot and knowing how to apply what you know? I've always seen a difference between smart and wise. A lot of people are smart. I grew up, I mean, Itchy had his PhD in history. All of his friends had PhDs. Not all of them were wise, but they were all smart. So I figured out a lot of judges are very smart. Wise, how to apply what you know is really important. And I found that the people I did best with as leaders were the people who gave me lots of room to be who I was. As long as the integrity issues were off and we've been lucky with the judges in this country. You don't get integrity raps. You don't have bribery stories. You don't have what's going on in the United States. So good leadership is the same everywhere, and that is somebody who wants their organization and the people in it to be the best they could possibly be on behalf of the wider interest of the public.
Great. Thinking about, you mentioned Itchy, your husband, and he was a history professor at York University of great distinction. How important was your spouse to your success? I know that my spouse who's here, and she was important to mine.
How important was he to your success? There isn't a word in the English language to talk about how important he was. I would say indispensable begins to describe it. He was the mother with the beard. He was my advisor. He was my supporter. He was the one I could be really petty with, come home and talk about awful things that I knew I shouldn't be talking about, but he understood. He also told me when to drop it, which is very important, let it go, and when to keep fighting. But I knew he was always there for me, and he was never afraid when I got into trouble, my controversies. He just kept pushing, you believe in it, you think it's the right thing to do, who cares whether people agree with you or not? I just could not have done it without him, or frankly, my mother, who lived 40 years after my father died, and was there every day, and was the first cheerleader I ever had. Because both of them believed in me, I was afraid of no one and nothing. I didn't like controversy, but I knew it was my job to say and do the things that I thought were the right things to do. And he was the center of the family, and the family was the center of our world. So, I mean, it's not, there are, I know that you know how that feels. I know Janice knows how that feels. I know that David knows how that feels. If you're lucky, you find that. Because if you think about it, how do you know in your early 20s who's going to end up being amazing? Right? To you, who's going to be I mean, you fall in love because hormones are working. What can I? And I fell in love with him because he was the smartest person I'd ever met in my whole life. I didn't know what kind of a father he would be, what kind of a son-in-law he was going to be, what kind of a supporter he was going to be. We went on a journey. He was 6 years older than I was. That made a difference too. So I think I was forever 19, and he kept waiting for me to grow up, and that never happened. But it was so central to everything I cared about in my life. And my sons will tell you the same thing. He was the heart of the family. And I was unifying. I was unifying because a lot of conversations started this way. Didn't Mommy say the most ridiculous thing you've ever heard? So I bound them together. I was the one they made fun of. But he was the heart.
So let's turn to some of your judgments that have had significant effect over time or not. And one of them is the Saskatchewan Federation of Labor and the valorisation of labor's rights. That was an important judgment of yours. And it led to the Government of Canada legislating back the CNCP workers, forcing them back to work. And it's going to be tested in the Air Canada strike. Feel free to correct me.
No, I'm not going to correct you. Because nobody understands judgments, even the people who write them. So it's... So the Saskatchewan Federation of Labor case was a decision of the Supreme Court that I wrote with strong dissents from a couple of my colleagues. As part of a trajectory, I mean, one of the things that we have in this country is a common law evolutionary approach to law, which then was transferred over into the way the Supreme Court of Canada interpreted the Constitution. Constitutional law, for those of you old enough to know, used to be at law school a very thick book of cases, 700 pages if I remember, although I remember none of the cases in that book, about what the difference was between whether something was a federal or a provincial act. I could care less whether an egg marketing board was federal or provincial, but that was constitutional law. In the meantime, the Warren Court in the United States, while I was in law school, 67 to 70, was muscular and robust. And so I thought that's what a Supreme Court should be like. And in fact, when we got the Charter of Rights and Freedoms, the people on the Supreme Court of Canada at the time, notably Brian Dixon and Bertha Wilson, ran with it and said, we are going to be a strongly protective Supreme Court of rights. We're not going to take baby steps and see how it feels along the way. They came out of the gate striking down the criminal code provision on abortion, striking down barriers to developing the equality jurisprudence, sometimes for the accused, sometimes for the Crown, but really bold decisions. And so the theory that I came to appreciate on the Supreme Court and followed when I was on the Court of Appeal was, you develop a constitutional approach that is sensitive to the possibility of increasing protection for rights. That's what the Constitution is for. Now, the government has the right to limit them, but they've got to justify any limitation on rights. The first time we dealt with labor rights was in 1987 in a case called the Labor Trilogy out of Alberta, and the Supreme Court with the exception of Brian Dixon, said collective bargaining is not protected by the Charter of Rights and Freedoms. 30 years later, this is, I know we're getting on tricky ground. When do you overturn a precedent? We overturn it when it's anemic, sclerotic. We never overturn it when it's expansive of rights, unlike our neighbors to the south. So 30 years later, lawyers brought back the case of is collective bargaining protected by the Constitution? And this time, the court said, yes, collective bargaining is constitutionally protected. And then the question was, is the right to strike constitutionally protected? Building on what we had decided on collective bargaining. And we said, yes, the right to strike is constitutionally protected. It was hugely controversial, protecting the right to strike. It still is hugely controversial. But in the meantime, all of these controversies start conversations. I wrote the first Court of Appeal gay rights decisions, and they were really controversial. But with each judgment that I wrote in gay rights, it was less controversial, and eventually, the first time I wrote a decision, they said, on the Court of Appeal, they said, Abella strikes down the anal intercourse provision for teenagers. Outrageous. 3 years later, I wrote a decision on pension benefits and struck down the provision that didn't let people leave pension benefits to same-sex spouses. And this time they said, Court of Appeal got it right. When they liked it, they said Court of Appeal got it right. When they didn't like it, they said Abella. So we were evolutionary in the way we developed rights. And they were always controversial when we first articulated them. Not surprisingly, there are settled expectations and you're changing them when you make these decisions. What's happening now is that decision that was so controversial when it came out, the International Labor Organization is, based on that decision, looking at whether or not the international labor environment should have protection for the right to strike. So, I mean, you can't do it in the hopes that people are going to like what you did and said. That's why I was there. Didn't have to worry about losing my job till I was 75. And by the way, I think that's a great idea. The Americans with this, you get to choose when you go, whoa. Who is going to say, who likes their job and thinks they're doing a good job, and everybody always thinks they're doing a good job, is going to say, yep, right, I have nothing more to contribute. What a dumb system. So you've got a sell-by date. You know when you're appointed. That's it. Thank you. Time for somebody else. So I love the idea that you have a duty to be controversial if you think it's the right thing to do on behalf of people. The legislatures can't do it. Or they can't do abortion. They can't do gay rights. They can't do labor rights without incurring the wrath of a huge chunk of people. And a good Supreme Court can.
In the immediate aftermath of the patriation of the Constitution, the government recognized that the Charter was going to be fundamental and that access to justice was going to be very important. And the government funded the Charter Challenge Program, which disappeared over time, but that's what drove Brian Dixon to where he was going. Do we have equal access to Canadian justice?
Access to justice is one of those buzzwords like rule of law that everybody uses and doesn't understand. Let's look at what real people feel about access to justice. If you have a custody dispute, if you have a workplace dispute, do you want to wait years to find out if you're entitled to a remedy? There was an article written in 1906 by the then dean of Harvard Law School, Roscoe Pound. Actually, it was a speech that he gave to the American Bar Association, and it was called Public Dissatisfaction with the Civil Justice System, 1906. And he said, the trouble with the civil litigation system is that it's too expensive, too acrimonious, too adversarial, Lawyers are at risk of becoming a trade rather than a profession. And I read that speech and I thought that was 1906. If you asked people today what they think about the justice system, civil justice system, they will say, even the ones who've gone through it and won, too expensive, too adversarial, can't get a remedy, it's impossible. Okay, think about this, 1906. How did people get to this American Bar Association conference? Horse and buggy, train, no planes. How did doctors perform their responsibilities in 1906? Maybe leeches, I don't know. We had child labor laws. We know what the laws were about women. We had segregation, 1906. If you took a lawyer from 1906 and put him, because it would have been a him, in a courtroom today with a couple of hours in preparation, he'd feel totally at home. Doctors have experimented with life in order to find better ways to save it. We still do justice exactly the way we did. We've tinkered around the edges. Now we have arbitration. I don't know if there are any lawyers in the room. If you want an arbitration, because the cathedral is the court, even arbitrations have become like court hearings because that's what lawyers feel comfortable with. The idea of a less formal, let's just get the remedy. Why do I need 5 weeks of trial to find out? Okay, so I don't think we've been gutsy enough to insist that the legal profession change the way it delivers justice to the public. But we have lots of conferences, lots of articles, lots of goodwill, and take a poll of people who've been through the justice system and how happy they are. After all, we are supposed to be there for the public, and I think you'll have your answer.
The last question. I want to turn to the arts and the law. And as Janice mentioned, you are a graduate of the Royal Conservatory of Music, an accomplished pianist. You appeared in a film on your life called Unprecedented, which I highly recommend to everybody. How did you come to agree to Barry Average doing the film? And what's the role of art and music and film in your life? And what's the role? What role did it play in your formation?
Can I start with the second part first? I cannot be in a room that doesn't have music. I play jazz when I'm researching something. I play Broadway music when I'm just hanging out. And I play classical music. Have it on. I now have Sonos. I have Sonos. I can't believe I have Sonos. Classical when I'm writing, when I'm doing my hard thinking. But the reason I got Sonos was because I leave it on all day so that when I come in the house, there's music. And I turn it on from upstairs so that when I come downstairs, there's music. I'll tell you how it affected me in a way that has, in a way, nothing to do with music. I wasn't an easy pianist the way my sister was. She was a genius. She had a perfect ear, sat down for 20 minutes and could play anything and can still do that. I was 2 hours a day. I was the tortoise. But because, and any immigrant in the room will understand this, because I had to be good at piano, and we had the Kiwanis Festival every February and the conservatory exams every June, 2 hours a day, I knew I had to do well at school. Nobody told me to, but I had to do well at school. My mother, from the time we came to Canada, sent us to the library. I had to read 3 books every week. So because it was part of my growing up, I have never in my life felt I've got too much on my plate. It's the only explanation I can have, because I have had too much on my plate, but it never felt like too much on my plate because of the way all of that stuff was kind of happening.
You were on the Giller jury one year.
97 books. So
that was the question. How many books?
And that was great because the book that had won the year before I got on was not popular. And Jack Rabinowitz always had people who understood books on the jury. You can see why he would want to do that. But because the choice that year, and I won't tell you what it was so unpopular, he decided to go rogue and put somebody on the jury who just liked reading but knew nothing about literature, whatever. So I was on the Court of Appeal when the books would come in, and they'd come in boxes of 8 or 10 or 11, and they were my carrot that I dangled. You're not reading those books until you finish that judgment. And so I was completely up to date, and the books were dessert. It was like whipped cream reading those books. I teach law and literature at Harvard Law School. Between us, I've never even taken literature. But literature affected me so profoundly growing up. I wanted to be a lawyer because my father had been a lawyer, but I had no idea what that meant until I read Les Miserables when I was 13 and figured out that that's what injustice was. So because I learned about human nature from literature, I thought teaching it to law students who I teach comparative constitutional law in the fall. I do the doctrinal stuff too, but I want them to understand people through literature because it's the best way to understand and be empathetic. So it's not books that have lawyers in them. I don't do To Kill a Mockingbird or The Trial or anything. None of my readings have a lawyer or a judge or a court case in them. They're just literature, a play, a novel, and a short story every week to teach lawyers how to think about people and relationships.
That was just absolutely wonderful. Wasn't it wonderful? It was just wonderful. Really wonderful. You know, I have to say, every time I have the privilege of listening to Rosalie Abella, I come away with gems, all right? Tonight was no exception. Rights expanding, right? That's what we do. We don't do rights contracting, we do rights expanding. That's a good motto, Mel, that we could all take away for this country, right? How do we expand rights? And if that's the lodestone, which it was for Justice Abella, that's the screen by which you judge. I don't think anybody could say it better than that, in a sense. Leadership. You act in the public interest. That's what leadership is. David knows that. You act in the public interest, right? You have to have courage to do that because there are lots of pressures that come from many different directions not to do that, but you act in the public interest. What made Rosie's life possible? Her husband, the support. I had the privilege of knowing him as a historian, and he was that, but he was also the absolute rock-solid foundation. We all need that. We all need that. We find it in different places, but if you're going to be bold and daring and courageous, and you heard those words so often from Justice Abella tonight, you need someone. And we all have to look for that, and we all have to be that someone for people who are taking the risks. And we have to be there to support and show up to support, and that's what community is all about, frankly. And last of all, a wonderful description of literature. I'm so glad you asked that, Mel. Rosie talked about music. I would talk about art. Jane knows that. And for the reasons that you just did, Rosie. But what's literature? How did you explain literature to us and why we should all read and not something we need for our work? That does not count. And I say that all the time because it helps you understand people And Rosalie Abella's life has been all about understanding people and making the law bend to express what people need and what people want. So thank you, Rosie. Thank you, Mel. It's always wonderful. But thank you, the two of you, for the privilege of spending an hour with you. And thank you, David, for making it all possible.